10 seconds to go. The agreed conclusions have been formulated within the framework of the Constitution of India. The constitutional relationship between the state of Jammu and Kashmir and the Union will continue as it has been, and the extension of further provisions of the Constitution to the state will continue to be governed by the procedure prescribed in Article 370. There will be no weakening of the ties which exist between the Union of India and its constituent units, of which the state of Jammu and Kashmir is one. The existing jurisdiction of the center to deal with activities directed towards questioning or disrupting the sovereignty and territorial integrity of India, or bringing about secession of any part of the territory of India from the Union, will also continue. It has also been agreed that any amendment of the Constitution of the state on certain specified matters of importance will not become effective unless the assent of the President is obtained. The agreed conclusions seek to reassure the state that in case the state government comes up with any proposal to change any central law made after 1953 on matters in the concurrent list, such as social welfare measures, cultural matters, social security, procedural laws, and the like, the grant of assent to the bill will be sympathetically considered. A proposal was made by Mirza Afzal Beg that the jurisdiction of the Supreme Court in relation to the state should be curtailed. This was not accepted, as it is considered important that the Supreme Court should continue to have its original and appellate jurisdiction in the matter of writs, appeals, and other matters. However, it was agreed by collateral letters that the provision in Article 132(2) enabling the Supreme Court to grant special leave on the refusal of a certificate by the High Court need not apply to the state. Action on this will, however, be taken only when the state government comes up with a proposal in this behalf. Honorable members will notice that the question of nomenclature of the governor and the chief minister could not be settled. This is a matter which is provided for in the state constitution, which at present uses the expression governor and chief minister. A change in the nomenclature can be made only by amendment of the state constitution by the state legislature. So far as the chief minister is concerned, there should be no objection to the adoption of the designation prime minister in the state if the legislature of the state of Jammu and Kashmir amends its constitution accordingly. Until this is done, the present designation would continue. Sheikh Abdullah was very anxious that to start with, the constitutional relationship between the state and the center should be as it was in 1953 when he was in power. It was explained to him that the clock could not be put back in this manner.